Hello, welcome to the Gathering Facts section of the UOV Justice Center website. Glad to have you. The information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. In this section, we'll be reviewing: where am I in the process? What is the purpose of this step? What do I need to accomplish during this step? Who do I send letters and notices to? When and how do I send letters and notices? What is the timeline? What is expected to happen next? And the 5 important rules of evidence. So let's jump into it. Where am I in the process? This is the beginning stage of your case. Here you should collect any evidence needed to help support your case. This evidence includes doctor's letters, police reports, witness statements, contact information, photographs, and any material that can be preserved for your trial. From there, you will determine legal elements required to establish your case. You will do this by taking your facts and comparing it with our table of legal actions. This should help you understand what type of case you need to file and when and where. Moreover, keep in mind our 5 important rules of evidence as you collect your evidence, and think about how the rules might impact each piece of evidence you collect. What's the purpose of this step? The purpose of this step is to freeze or to put a hold on all the evidence needed to prove your case, and to make sure the evidence is as fresh as possible. After an incident occurs, memories fade, records change hands, or are destroyed, or things are lost. For that reason, if you believe you have a lawsuit, you should act to freeze all evidence that you would need in order to prove your case. To know what evidence is important and the source of the evidence, you should complete the facts gathering worksheet. What do I need to accomplish during this step? By now you should have conducted your legal research, completing those forms, as well as the fact-gathering worksheet. These forms help determine if litigation is needed, and if so, what would be the reason for litigating. Once that is all figured out, this helps to obtain proof of claim or defense to help you have a better chance on winning your case. This is accomplished through a few documents. These documents include document requests, witness statements, letters to preserve evidence, and any other tools that can be used to get evidence in a legal case prior to filing a lawsuit. Who do I send letters and notices to? You will send letters and notices to any potential witnesses, people, businesses, and organizations that might hold evidence. Doctors, schools, extracurricular, and other facilitators of social life, and any other person, party, organization, business, public agency, or source other than yourself that might have evidence that you do not have access to, and where the evidence will prove your case. So, when and how do I send the letters and notices? You will send out letters and notices to preserve evidence the minute you realize something is wrong and you might need to file a legal action. Because of the statute of limitations, it is important that you move quickly in your case. You do not want to miss the opportunity to file your case. The documents needed to collect evidence can be delivered in any way that allows you to keep a record. What is the timeline and what is expected to happen next? This should be a quick phase. It is the planning phase so that you understand how to approach your investigation. After this, you would engage in the investigation phase. The investigation phase allows you to better understand the facts of your case in relation to the law, to prioritize what is important to prove your case, and defend yourself against their case. Here are the 5 important evidence rules you must know. Relevancy. Only evidence directly related to the credibility of a witness and the outcome of the case can be presented. Foundation. You must prove that every witness has personal knowledge of every fact they are testifying to. Authentication. You must prove the evidence you are presenting in court is real and accurate. Hearsay. You cannot prove something is true because someone says it's true unless the person who said it is true, has personal knowledge of the fact, and they are available themselves to come to court to testify about what they heard, saw, smelled, or tasted, or felt. Character. You cannot prove that someone did something just because they have done that thing or something like it before, except for of limited circumstances. This has been an overview of the Gathering Facts section of law. On behalf of the ULV Justice Center, we thank you for your time and hope this information is helpful in your legal matter.